publicly embarrass Chairman Zwanitzer. He is literally stuck in his driveway. He called and said, I'm buried in a snowdrift in my driveway and I have to get a tow truck to get out. So Representative Jennings was nice enough to come in a little early, so we'll hear his bill first. So first bill up is going to be House Bill 161, but before that, Mark, would you take the roll, please?
Representative Banks,
Here.
Representative Conrad,
Here.
Representative Heiner,
Here.
Representative Knapp,
Here.
Representative Larson,
Here.
Representative Lawley,
Here.
Representative Tarver,
Here.
Representative Western, Chairman Burkhart.
Here. Okay, so we have a quorum. Just a reminder, if you'd turn your cell phones to vibrate or off or silent or something, and remember to address the chair. So with that, Representative Jennings, take us through your bill.
Thank you, Mr. Chairman and committee, for hearing this bill this morning, House Bill 161. This was a constituent brought a issue to me that I actually, to be honest with you, thought probably was already being taken care of in our lending institutions. And many times, as I began to talk to other people about it, I found out that they did not know that just because you co-sign does not necessarily mean that you will receive the benefit of whatever property or whatever you've co-signed on. And so I thought about that in talking to this constituent. And I'm not one that likes to add paperwork, in case there's anybody there in the banking industry behind me. That having been said, I thought it was not fair. The meat of the bill is really on page 2. Starting on line 9, is that this would require lending institutions to provide notice to the guarantor or cosigner that just because they sign on a note as a cosigner does not guarantee any right or interest in the property that they are co-signing for. And many of us have co-signed on something, and I don't know what triggers in our mind, but most of the time we haven't got a contract or an agreement in place. And so this would just be the lending institution giving us a disclosure notice. And then B is just saying that it shall not affect the right or the interest in that property. And so it's really very simple. Stand for any questions.
Questions for Representative Jennings? Questions? Representative Western.
Thank you, Mr. Chairman. Representative Jennings, my understanding was that especially if you request your loan docs ahead of time in the mortgage statement as well as the loan statement, that makes it clear that the cosigners are simply guaranteeing the loan itself and not has an interest in the asset.
Representative Jennings?
Thank you, Mr. Chairman. Representative, I think that's typically in that packet or to that book that they give you that you have to sign for 6 hours. But I think that the practical application out there to the cosigners is that most of the time they do not understand that they would need an agreement to protect themselves as a cosigner. And so this would just be, it would just address that. You could go back to the buyer beware. I think this just probably adds a piece of paper. It certainly does, but it makes it clear, kind of a consumer protection.
Follow up? Okay, good. Anyone else? Okay, I think it's a pretty straightforward bill. And I was telling Representative Jennings earlier that I've actually seen this in a negative way from people. So with that, Representative, hang with us. We may have more questions. So with that, any legislators in the room wish to speak? I'll open public testimony. Anyone from the governor's office? Okay, any agencies? Come on up. You coming up too, Scott? You're going to tag team this? No, I'll let you. Okay. So the usual, please identify yourself and for the record.
Yes, thank you.
People
Good
that are
morning.
watching online.
Jeremiah Bishop, the State Banking Commissioner, head of the Division of Banking. So I think we discussed last week, we administer Title 13 and we are the bank regulators. It's a pretty short bill, so I don't have a whole lot of comments on it. Generally, there's nothing to really discuss too much on the bill. Our job would to be ensuring that banks comply with this new bill and that they provide this disclosure to cosigners and guarantors. Note that this bill only applies to financial institutions in that definition, so not national banks, but it would apply to state banks and in this case, credit unions. However, we would not be enforcing this on credit unions because we do not regulate credit unions. One thing that was unclear is just there are other non-banked lenders that have guarantors and cosigners, and we just weren't entirely sure of the intent of this bill. Some of those institutions are non-bank lenders, mortgage lenders or auto lenders. Those are not, those lending institutions do not fall under Title 13. There's the Mortgage Act and UCCC. And so we just weren't entirely sure if this was just supposed to be limited to banks or if there were other lenders that needed to be fall under this. And then very broadly, the term property, it's very broad. It doesn't provide a specific definition. However, this is intended to cover any and all collateral or I guess any purpose that the loan was to purchase, then I think that's fine. But yeah, I wouldn't, that's all the prepared comments I have, I guess, was just, we just wanted to make sure we understood kind of where this was coming from.
Okay, questions for Commissioner Bishop? Any questions? Okay, Commissioner, I have one. Because the bringer of the bill mentioned it. Do you see much in the way of additional paperwork to do this for the banks?
Yes, thank you, Mr. Chairman. Yeah, it would be a single disclosure, so a single paperwork. However, realistically, anytime there's a cosigner or guarantor, they are already signing some type of other agreement, whether or not, especially the guarantor agreement. And so one of my questions was whether or not this was included in that guarantee paperwork, or should it be a separate disclosure? If we agree, if you all agree, it should be a separate disclosure. I mean, that's just one more piece of paper that they have to sign and disclose on. But I might lay that up to the Bankers Association to maybe clean up on that.
Okay, all right, thank you. Any other questions? Representative Western.
Thank you, Mr. Chairman. Mr. Bishop, obviously FDIC banks are heavily regulated. Some are in your purview, and then of course some are nationally chartered. But for all the, there's a bunch of different financial institutions that can make loans, credit unions, et cetera. I mean, some of these private credit institutions, are they also all required at the same level that FDIC banks are for financial disclosures, these types of nature? I mean, are they also, they're all equally subject to the Truth in Lending Act and some of those other ones that make sure that there's full transparency? Are they the kind of equal playing field there, or equal requirements rather?
Commissioner?
Yes, thank you, Mr. Chairman. Thank you, Representative Western. Yeah, there are all these other non-bank lenders. There are a number of consumer protection regulations that they need to be in compliance with. Our office also regulates some of those institutions, just not under Title 13, and that's generally what we're looking for, is compliance with some of those federal lending compliance issues. So,
Good. Any other questions? Okay, Commissioner, thank you.
thank you.
We may have some more questions, so. Okay. Any other agencies? Okay, general public. Mr. Meyer, come on up.
Morning, Mr. Chairman, members
Morning.
of the committee. I'm Scott Meyer, and I'm President and CEO of the Wyoming Bankers Association, representing all of your community banks. We're scratching our head a little bit. I'm not sure I understand the actual issue as to whether they have whether a guarantor has an interest in the property. I guess I just don't know, and my bankers are scratching their head a little bit too, thinking, I'm not sure what we're trying to accomplish here. The guarantors do have to sign, as the co-signers on a note or whatever, they have to sign an agreement that says, yes, we understand that we may be held liable. If there's a default on the note, the guarantors and other co-signers know that the banks or other lenders have the right to take the path of least resistance. And so there may be other avenues to go after a debtor, but if the guarantor is there and they have the resources, they'll go straight to the guarantor. And I don't know that this bill does anything to change that. So I look at it and say, I'm not sure what's going on. If it does take one more piece of paper that says, and by the way, we want you to acknowledge you don't have an interest in this property, it could be. I mean, it's one more piece of paper, but there's one more piece of paper, and I think we'd like to get rid of as much of that as we can. But I honestly, members of the committee, I don't understand this bill.
Committee, questions? Representative Conrad.
Mr. Chairman, thank you. Mr. Maher, thank you as well. It's from your perspective, which I'm in agreement with, it seems fairly duplicative. Is that, I mean, we're already providing this debt as Representative Western pointed out earlier. So I guess there is no question here. I guess I'm reaffirming my question as well as your question. What are we trying to accomplish here? And could you provide any insight? Is there any merit to what we're trying to do?
Mr.
Brown?
Chairman, Representative Conrad, I'm with you. I think it is duplicative unless there's something out there, but I literally have talked with almost a half of my members out there at the different banks and said, do you understand this? And they don't understand what the issue is. So I'm happy to go back to them and say, here's the issue. We're all missing it somehow, but I don't know what that issue is. And so we're pretty much neutral on the bill. I'm not sure it's needed whatsoever, but I would just like to have that clarification.
Okay, thank you. Any other questions? Okay, thank you. Just hang with us. We may have some more questions. So anyone else wish to speak on this bill? Anyone else? Okay. I think before I close public comment, though, I'm going to ask Representative Jennings to come back up and maybe answer some of these questions that were raised. Is that acceptable to you, Representative?
Yes, sir. Mr. Chairman, committee, happy to do so.
Proceed.
So the two things to begin with, and I forgot this in the very beginning, I think many banks do the tell. In fact, that's actually how this came about, was the constituent had co-signed on 10 or 12 co-signers and was under the impression, wrongfully so, and many times had an agreement or a contract already drawn up to take care of this. But it was about the 10th or 11th time when one of the loan officers said, you realize that you'll have no interest in this if you don't have an agreement. And so through thinking about that, like I said, I think good loan officers probably disclose this already. They think about it and they say to the co-signer, you realize this does not necessarily give you interest in the property. But I think the bank or the lending institution, and that was the other question, was this is only for financial institutions. It's not reaching out into, your brother-in-law or somebody like that. I think that's a good point of contact for information. And so for those people who don't, and from the people that I had talked to, many of them have signed on to stuff, or I think you had a very good example where a husband passed away and had co-signed on a bunch of stuff, and the wife just hadn't been made aware of it. And so that seemed like the place to put, unfortunately, that one more piece of paper, which I'm usually against. It made a good place to bring that information to consumer protection.
Okay, thank you for the explanation, Representative. Any questions for the representative? And Representative, I understand about the paper. I've signed some bank papers that you look at it and you turn it over wondering, how many times did they copy this on the copy machine? Is this really a real legal document? So, okay, thank you. Oh, I'm sorry, Representative Western.
Thank you, Mr. Chairman. Representative Jennings, could you maybe provide a little bit more context in their constituents' circumstances? Was it on an auto loan? Was it, personal property or real property, or was it a mortgage on a home?
Representative?
Mr. Chairman, Representative, actually in the constituent that brought this, it was a number of each. And they just hadn't been made aware of that. And like I said, I think that the banks, many loan officers are already doing this, but the piece of paper makes it sure that they have that.
Representative Lawley.
Thank you, Mr. Chairman. Representative Jennings, would, to kind of address the extra piece of paper part of this, would it be acceptable if there was some method of elevating the disclosure that's already in the paperwork, making it bigger, bolder, somehow? Because it seems to me that's kind of the issue, is it's being overlooked, which anybody that's signed a lot of documents knows it's easy to overlook a lot of it. But would that somehow meet the need you're going for without another piece of paper, but elevating, again, through type or highlighting what's already currently being disclosed?
Representative?
Thank you, Mr. Chairman and Representative Lawley. So I think that might be better addressed to the banking institutions because, again, I think that good loan officers are many times disclosing this as to what they're already have on paperwork. I don't know. I don't recall the few times that I've co-signed. I don't recall someone ever saying to me, "Hey, you realize that if you don't have a contract, you don't, just by co-signing, you're obligated to us. You're obligated to the loan." But I've not had a lot of experience in that. And like I said, the banking, I don't know what theirs looks like. I wasn't aware of them having put that into their disclosure. And so that's why this piece of legislation is just to cause them to help disclose that information to the guarantor.
Follow-up?
Yeah, thank you, Mr. Chairman. So again, you don't currently know what the disclosure is, but you're wanting a specific disclosure on another piece of paper. So I guess I'm trying to understand if there is a disclosure, and we'll maybe bring them back up, because I do think it kind of balances the issue here to say that maybe the disclosure needs to be more highlighted, because clearly, I mean, I even know of examples where people overlooked that. They didn't understand that. So, this is a problem with a lot of the disclosures. As we add more paperwork, I believe that there are people that, there's less incentive to know what you're signing because it seems overwhelming, quite frankly. So again, I'm just trying to address that issue of is there another way to accomplish the same thing by elevating the disclosure that might, if there is a disclosure there, which I believe there is a disclosure in most of the paperwork, but again, I can't say either. But I just wondered how you felt about that.
Representative?
Mr. Chairman and Representative Lawley, so in the LSO, the research to that, they did not come up that it was legally already that it was required. And so, like I said, I think it's something that good loan officers probably, if they think about it, they do. And maybe inexperienced or not quite as conscientious loan officers might not always make that cosigner aware of. And so that's why the disclosure.
All right. Oh, Representative Knapp.
Mr. Chairman, thank you. Representative Jennings, with the language of the law currently, if the bank did have a disclosure already written into the agreement, they would be complying with the law. So it wouldn't be any extra to have that. It's just saying that if they don't, you would like that to be added.
Representative?
Mr. Chairman, Representative Knapp, that's correct.
Okay, other questions? So, thank you, Representative. I think, Mr. Meyer, do you want to come back up and maybe address any of those questions? If not, that's okay. I've just given you opportunity. Okay, if you would, please. And go ahead, proceed.
Thank you, Mr. Chairman. I would stand to agree. I mean, I don't know every single loan document that's out there, but I would tend to agree that they're already being disclosed in there. I guess I'm still scratching my head as to the property interest. I don't know that any guarantors have been ever said, remember, you don't have an interest in this property. The lenders don't care whether you have an interest. They want to know whether you have the wherewithal to back up this loan. So I'm still not sure of the issue, but I would agree with Representative Lawley that I think that those are already in the documents. They're already required to do that. The CFPB, the State Banking Board, everybody has regulations It's probably one of the most highly regulated industries out there is banking. So you can't really do anything without paperwork of some sort. So I think that we've probably already got it covered.
Okay, thank you. Any further questions? Okay, gentlemen, thank you. One last time, any more public comment? With that, I'll close public comment. Committee?
Move the bill.
Moved by Heiner, seconded by Knapp. Committee, any discussion? Representative Western.
I certainly agree that disclosure is a very important part when you're going through any of these processes. And, I certainly, whenever I do this kind of stuff, I always ask my commercial lender to have me send that contract ahead of time so I can go through it. But I appreciate there's a lot of folks, especially on auto loans, those kind of things that, might not be a sophisticated borrower. So I certainly appreciate there's a real need for disclosure. And all my interactions with our community banks, they're pretty good about making sure we're all on the same page in what we're getting into. I think that, it's definitely redundant. I'm certainly fine with the discussion about having this, making sure it's in the documents that already are. I mean, I think it's 6 or 7 different documents that you have to sign, your mortgage statement, the loan agreement, the promissory agreement, all those kind of things. So I think just, if we just struck the separate document component, that way banks have to have a whole nother set of paper, but maybe you could strike and say must make clear and conspicuous in documents that are already provided. Yeah, I think that might.
So Representative, this is really a one-page bill, maybe 2, if you look at the title page. So are you proposing an amendment?
Mr. Chairman, I am.
Okay, and where
It
are
would
you,
be
please?
page 2, line 8, strike after the period, after loan, strike the disclosure shall be separate. Or should be the shall be separate component, say the disclosure shall provide. So shall be a separate and is what we're striking on page 2.
Okay, so I'll repeat that. Line 8, after disclosure, strike 4 words, shall be separate. Am I correct?
A separate document and.
Shall be a separate document. Okay, and. All right, thank you. That's why we do this. Okay. Mark, do you have that?
Chairman, what I understood was after disclosure on line 8, page 2, strike shall be a separate
Document.
Document and,
document and, okay,
those 6 words.
yes, I do. Thank you.
Okay. All right. Is there a second on the amendment? Seconded by Tarver. Committee, discussion? Okay, all in favor, say aye. Aye. Opposed, no. Okay, amendment is adopted. Okay. Any other discussion on the bill? Question being called. We are voting on House Bill 161, loan disclosure for guarantors and cosigners. Mark, would you please call roll?
Voting on House Bill 161, Representative Banks,
Aye.
Representative Conrad,
Aye.
Representative Heiner,
Aye.
Representative Knapp,
Aye.
Representative Larson,
Aye.
Representative Lawley,
Aye.
Representative Tarver, Representative Western, Chairman Burkhart,
Aye.
9 ayes, 0 noes. Is that do pass with amendments?
Okay, so House Bill 161, loan disclosures for guarantors and cosigners as amended has passed committee. Thank you, Representative. Okay, Chairman Zwanitzer, we see that you've dug out and made it, and Chairman Harshman, thank you for getting here a little early. There was some confusion and Chairman Zwanitzer now knows tow truck drivers on a first name basis. So next bill for consideration is House Bill 91, New Source Shield Law. So Chairman Zwanitzer, proceed.
Good morning, Chairman Burkhart and members of the Minerals Committee. Pleased to be here today, and it's been a long morning already, so thank you for the indulgence. It was, everybody on the entire road for about a mile got stuck in their driveways this morning. So I am pleased to bring you House Bill 91, News Source Shield Law. It was, I'll say, an old friend of the legislature. I did bring it 2 years ago, passed the House, didn't make it through the Senate. Basically, what it does, a shield law or journalism shield law is protection for journalists to not have to disclose their sources. Every state besides Wyoming and Hawaii now has a shield law in their books. So we're one of 2 states left. I do think you'll hear from people behind me that this privilege or this immunity is not used lightly and only in the gravest of circumstances. And I do think it is important, maybe paramount in a state like Wyoming where everyone knows everyone. And if there was a type of nefarious activity or something controversial, you'd know it was between 3 or 4 people, and their identity protection would be paramount in those circumstances. So happy to walk you through the bill quickly, Mr. Chairman and committee.
Please.
So on page 2, this just talks about what news information means. And so we're always trying to differentiate, gossip from what's, credible news information. And so you'll see in the definition there, when this would go into 112.701, what news information is: written, oral, pictorial, photograph, emails, and the identity of the source of that information. Then we go into the privilege there in the bottom of page 2. And so this does apply to current or former journalists. So just because you leave the profession doesn't mean they can automatically demand you reveal your former sources. As long as you've obtained that information in 2 ways. You can go search it out from an individual, or they can come to you, right? There will be what we would call a whistleblower, come to a news organization and, allege certain things, and the news information source would investigate and almost before publishing a story or using that to gain information in a news story. So you can there see what news information is on the top of page 3. And these definitions are from other states. We're not reinventing the wheel here. This is all pretty solid law that's been around everywhere since, the late 80s, all through the 90s. We're just about the last state to get on board. And then in some cases, because this language, has been around for 20 years, I know there's some amendments and some talk about adding internet instead of just radio stations and television networks, podcasts, those type of things, I think will be part of the debate today. Moving on there onto page 3, when the news information is obtained, you'll see that we are generally keeping these in what I would say the news realm of newspapers, magazines, wire services. We have included websites, radio stations, and again, it does have to be for news. Then in 112.703, the provisions of law, basically the journalist is responsible for this information, and they get to generally decide what they would consider privileged in a court of law. And further on in the bill, we'll talk more about that. And it basically just nicely says the court, you can't sue somebody, you can't compel them to disclose that information as long as it's valid information and then being shielded from, protecting the identity of that witness or that news source. So you can't hold a journalist in contempt. You can't lock them up in jail. You can't do any things that, we see in foreign countries sometimes when it comes to the privilege of journalism and investigating nefarious actions. 112.704 on privileged communications. Just know that privilege is asserted whether it's the court, the legislature, any agency, executive or legislative branch, private company, etc. The privilege goes away if you'll see, well, that's later on. Let me go back to the top of page 5. This does also apply not just to what we'd consider like the newspaper, but this also can go to like the UW branding iron, shall we say. And so not only is a journalist protected, but their employer. So you can't lock up, the editor of the newspaper if one of their journalists, refuses to disclose a source. Same for students, right? If there's that privilege that's been extended to a student newspaper. The burden of proof is always on the journalist. And so we have had some conversations on what is and who isn't a journalist. But in this type of situation, the burden of proof would be on the journalist to say, hey, I'm a legitimate news journalist and this is legitimate privilege. And so we've gotten caught up, I think 2 years ago, some of our colleagues in the other body, really wanted a very tight definition of what a journalist was. But I tend to go back to that section saying, if this were to go to the furthest levels, they would have to prove the existence of, I'm, a true journalist and the privilege exists. There is some exceptions there, right, on the top of page 6, if that information they have will cause an imminent risk of death or serious bodily harm, or if it's being used in a defamation action. So this is kind of, I wouldn't call it a loophole, but it's the catch-all that if you feel like it's just a simple defamation against another person or against their character, there is, a way to demonstrate that you could have that privilege waived in a defamation case, right? So it can't be used both ways, just to go after somebody and then they say that it's only used to defame to me. There's no legitimate news source here. That's a possible exception to compelling that disclosure. There's a waiver in 112707, so the journalist can waive any level up to what they feel comfortable. If it's out in other places in the media world, that privilege can go away, and it does allow that journalist to basically allow them the level of disclosure to who they want to in certain circumstances. And then we just have a provision in the rules of civil procedure that privileged information is used in the Wyoming rules of civil procedure and the rules of evidence. You'll just see that it's put in there that the criminal, in a criminal case, they would have to understand and follow those rules. It does become effective immediately, and I'd be happy to try to answer any questions.
Okay. Questions for Chairman Zwanitzer? Representative Western.
Thank you, Mr. Chairman. And I think, Chairman Zwanich, you kind of touched on certainly my concern is definition of journalist. Because if I'm wrong, please do correct me, but as I read this, basically anybody who says that they're a journalist gets this type of protection. It doesn't actually come down to any specifics, any quantifiable, hard metrics that, are bona fides that prove that they are. That could just simply, be a blogger and not follow journalistic practices, but I could still come up with and say this. And I think that's something, and we're talking here now in Wyoming, but that's something that's been an issue nationally with our media landscape, which I will not delve into. But I mean, Mr. Chairman, has there been did you guys at least make any attempt to define journalists, and what did that language look like?
Chairman Zwanitzer?
Chairman Burkhart, Representative Western, yes, many states have a definition of journalists. I would say they are outdated in their shield laws. Many of these passed 20 years ago before the rise of the internet. And it has been a conversation. It was a conversation in the other body 2 years ago on who is and who isn't a journalist. And I think that's where this bill has got hung up 2 years ago. And so we considered putting a definition of journalists, and there are definitions from other states. But instead in this bill, we really tried to define what news is. And so if you keep it to what, ensuring that it is in fact news and not salacious gossip, and it's used at a source, and you'll see there on page 3, the mediums that this would be published in and legitimate news publications. The journalist itself perhaps does not matter as much to me as long as it's being, it's some company, right? You're not, whoever's publishing that in the press association, a wire service, even a website, there is someone responsible and an owner, and usually, a corporation, et cetera. And most of these companies, they have professional ethics that they subscribe to, but because it's not a governmental, it's a trade association, right? A society of professional ethics and journalism, it's really tough to put that in statute. So I do think it's perhaps not appropriate to clearly define what a journalist is, because that does change. But I do believe what makes me feel comfortable is if somebody claims this privilege, they would, have the burden of proving they are a journalist. And I would think in those cases where somebody who truly has this information, and it doesn't happen often, right? We're not talking this is a monthly thing. This is a once every 5 or 10 years type of situation. If that person didn't truly feel comfortable they were a journalist, they would go seek out a more lofty journalism source, right? They might partner with a newspaper, with a radio station, with someone else to help disseminate that information. I think that would be the protection in many of these cases.
Okay, follow up, Representative?
Thank you, Mr. Chairman. Representative Chairman Zwanitzer, but do you feel that this bill draws that clear delineation? Because I certainly appreciate let's think of the famous examples, the Watergate scandal, the Snowden disclosures. Obviously, this type of stuff absolutely makes sense, but it doesn't make that clear delineation between that type of stuff or stuff of that nature and stuff that perhaps some might deem it quite serious and others might deem it as just simply gossip. And is that delineation made clear enough in this bill, would you say?
Chairman Zwanitzer?
Mr. Chairman, Representative Western, I believe it's about as clear as we can make it. It's probably the honest answer. Do I feel comfortable with where it is? Yes. Do I think it's airtight? No, because of just the ever-changing world around us of what is a journalist and a blogger, and I mean, everybody today, can kind of, I don't want people just scribbling notes and then putting them on a social media website and saying, hey, I'm a journalist. So there are, I think, professional ethics organizations that kind of delineate what a journalist is, but I do feel comfortable in this bill if we keep it to news information and where that news information can be published, that I'm not as concerned about the definition of a journalist. And again, that catch-all is in the law, that if this went all the way, that journalist would have to prove in a court of law that they are in fact, a legitimate journalist with a legitimate news story.
Okay, Representative Lawley.
Thank you, Mr. Chairman. Representative Swanson, I'm going to always get your name wrong. I'm sorry. But I want to follow up kind of on the same topic. So is your reading of on page 5, the burden of proof provision, you refer to it as a burden of proof to prove you're a journalist, but I'm not certain that's the way I would read the statute. But I just wondered, the way you've defined, you're focusing on the news, is it news gathering, which I totally understand why you did that, but does that affect, in your view, the way on page 3, Romanet 2, that you've defined news gathering? How does that interact with page 5 on burden of proof?
Sure.
Chairman Zwanitzer.
Mr. Chairman, Representative Lawley, and I believe a lot more of it comes into on page 5 on lines 15 and 16. It's the burden of proof is on the existence of the privilege. So it's not so much on whether or not you're a journalist or this is a news source. It's kind of the existence of the privilege in itself brings everything into play. So then you go back to news information definition. There would be a lot for a judge to consider, right? We try to keep that definition very broad of any written, oral, pictorial, photographic. And so it is, I think, designed to be very, very broad, but I believe you'll hear from the people behind me who are in this field and do this work every day. This is only used in the most, grave and rare circumstances, and it's certainly not used lightly, and would not be used lightly, right? In Wyoming, we have very few news sources. We have one political reporter for kind of each of the major 5. They can't afford to go too far without being replaced. It's just Wyoming's just a weird place where we all know each other, and there's very few professional journalists engaged in this. So I think there is room for other people to go to, their favorite news site, and people are finding their own news sites these days. But, I think ultimately the issue is if there's something nefarious going on towards a corporation, government, or business, people need to know that information and would hope whoever that person goes to finds a reputable source to get that information out there.
Any other questions for Chairman Zwanitzer? Ready? Okay, Chairman, hang with us if you would. So with that, I will open it up to public testimony. Any other legislators? Anyone from the governor's office? Any state agencies? Okay, the rest of you, please come on up. And if you would identify yourself for the record, please.
Yes, sir, Mr. Chairman.
And
Thank
you
you.
might have to get a little closer to that mic.
You bet. Good morning, Mr. Chairman. Good morning, representatives. My name is Brian Martin. I'm the managing editor of the Wyoming Tribune Eagle newspaper here in Cheyenne. I'm here today to speak in favor of House Bill 91, titled News Source Shield Law. I'm in my 25th year as editor of the Wyoming Tribune Eagle, and during that time, I've had the pleasure of speaking with a large number of Wyoming residents from all walks of life. Many of the people I've come in contact with, I've never learned their name, and they called me to report some concerns to them, but they said they wish to remain anonymous. Some of these callers simply had a bone to pick with a local business or an individual they felt had wronged them in some way. As a professional journalist who's trained with a college degree, both as a reporter and then later as an editor, I quickly had to learn how to tell which of these folks were calling simply to try to use the media to embarrass or retaliate against someone. However, through the years, I've also spoken with some incredibly courageous people, employees of state agencies, enlisted military personnel, school teachers, and federal workers who have seen wrongdoing where they work or fallen victim to sexual harassment or discrimination. Some of these individuals were willing to risk their jobs, their ability to support their families and their careers in order to expose the injustice or corruption. Others couldn't afford to take that risk, so they asked for a promise from me and a reporter to keep their identity a secret. Until recently, I'd promised that their name and phone number would remain solely in our files, not to be shared with readers or anyone else in the community. I felt I could guarantee that because I was sure that lawyers and the organizations that they represent would respect the anonymous sources who boldly step forward to speak with a reporter. However, I no longer feel like I can guarantee that that would be the case. More and more often, reporters are being subpoenaed and asked to reveal their sources, as well as to turn over their notes from interviews with these types of sources. And yes, it doesn't happen all the time in Wyoming, but it has happened here in the past. Without the protections included in the bill before you today, I can't guarantee that after a fight in court, which we would engage in, I would be able to prevent that person's identity from being exposed. You certainly already know of many of the famous cases where whistleblowers working with journalists have exposed government corruption at the highest levels, and Representative Western mentioned the Watergate scandal being the most famous. But let me tell you about a situation we had here recently in the capital city. Earlier this month, we began hearing multiple reports of people not receiving their newspapers, which since last August have been delivered exclusively by the United States Postal Service. We knew we had delivered all of our papers to the main post office on Converse Avenue by the 3 a.m. deadline, so we were at a loss to explain what was happening. It was only when I heard from a postal worker who asked to remain anonymous that the problem was revealed. You see, according to this employee, who we verified had worked for the USPS for several years, the interim postmaster was engaging in a practice called rolling mail. That meant she was consciously deciding to have carriers not deliver any mail at all in favor of delivering Amazon packages, which could be tracked by barcodes so that the customer knew how long it took to reach their destination. Only by speaking with this postal carrier and verifying their story through screenshots of text messages that they received from the postmaster directing them not to deliver mail and to instead deliver packages, were we able to expose this clearly improper action. Since this had occurred on more than one occasion, I have to wonder how many more times it might have happened that had we not called the USPS in Denver for comment and reported to the community what had been happening. Before the postal employee would speak to me, though, I had to assure them that they would remain anonymous. It was a promise that I certainly would do everything in my power to fulfill, but would be guaranteed by the passage of this bill, House Bill 91. Because there's no federal shield law to protect journalists from being forced to reveal their sources, and Wyoming and Hawaii are the only two states without any protection at the state level, we run the very real risk of not hearing from people who want to expose wrongdoing, like the rolling mail example I just gave. Of course, even though delayed Social Security checks, bill payments, and medications are bad enough, there are in fact worse things that need to be exposed by professional journalists and the anonymous sources who want to expose them. Improper use of public funds, embezzlement, abuse of power, and more happen all the time, but we don't know about it until someone steps forward to tell us about it. As I conclude my prepared remarks, I want to assure you that I and my professional journalist colleagues throughout Wyoming would much rather use sources who would give us permission to use their names. We grant anonymity only as a last resort, after attempting to convince the original source to go on the record and trying to verify the information through other sources who are willing to be identified. Some situations, however, are simply too important to keep from the public, and that's when we agree to allow anonymity. I hope that you will agree that Wyoming journalists use this tool very sparingly, and that both the sources and the journalists they speak with deserve to be protected in this way. Thank you, Mr. Chairman, and members of the committee for your time and your attention to this important matter.
Questions for Mr. Martin? Any questions? Mr. Martin, thank you.
Thank you
very much. Anyone else? Please, come on up. Okay, you two can fight about it. If you would identify yourself for the record, please.
I'm the general manager of KCWI in Casper and KGWN here in Cheyenne. Mr. Chair, members of the committee, thank you for hearing from us today. I'm a TV board member of the Wyoming Association of Broadcasters and here representing that organization and my own. The broadcasters of the state ask you to support HB 91. News source shield laws are incredibly important if you're involved in the news reporting business, such as our TV stations. The news gathering profession requires a certain level of trust between a reporter and those sources are frequently concerned with retaliation or punishment when sharing their sources. And those sources are frequently, some of them take big risks when talking to us. We rely on sources, and those sources might not share sensitive or critical information in the absence of anonymity, mostly out of fear of they're being punished for sharing it. I understand that some may believe that this is a solution in search of a problem. I would argue that the potential for application of this law exists every day. Many stories begin with confidential sources. That's where our work begins, not where it ends. Verifying what the sources told us, acquiring the publicly available documents, and interviewing the on-the-record sources are part of our process. If reporters can ensure confidential sources' identity, the public may never receive information on critical public safety, public policy, and corporate governance matters. As news reporters, we don't use anonymous sources lightly and use them only when we've explored every avenue available for a named source. If we choose to use an anonymous person, we check and double check to make sure this is a credible informant. This is a practice we use for all news stories. When it comes to a free press, anonymous sources can be very useful. Without them, journalists could simply not do their jobs. We'd be relying on the official side of the story. And the official side of the story isn't always the whole story. On behalf of broadcasters, we ask for your support of HB 91. I stand for any questions, Mr. Chair or members. Thank you.
Thank you, Mr. Beck. Any questions for Mr. Beck? Any questions? Thank you very much. Okay, it is your turn now. Even if someone else raised their hand, it was going to be your turn.
I thought you said we could fight over it.
So please identify yourself for the record.
My name is David Iverson. I'm the owner of Cowboy State Politics. I echo the comments of a lot of the previous speakers, including Representative Zwanitzer. It is absolutely essential that we have a free press. In fact, I think the Wyoming Constitution puts it most clearly that, and it's in Article 1, Section 20, that every person may speak freely, write, and publish on all subjects, being responsible for the abuse of that right. And so while I think that we absolutely have to have a news source shield law, I do have a couple of problems with this bill. The first one is in what is the definition of news? And I think that Representative Zwanitzer brought this up. What exactly is news? Do you have to belong to a professional organization, or do you have to work for a newspaper or a television station? I would submit that with the advent of the internet, the definition of what is news has been expanded quite broadly. In fact, my website, cowboystatepolitics.com, I mean, there's an argument to be made that it doesn't fit in the definition listed in the bill. And so I think that we have to find some language to include independent journalists in this bill. The truth is that most big news stories are not broken by your big news outlets. It's generally some sort of independent news source that finds something and then brings it to a larger news outlet. So I absolutely think that we have to include some language to include independent journalists. The second problem that I have with this is with the defamation part of the bill. The truth is many journalists are subpoenaed in defamation cases. And if a journalist is unable to protect their sources, nobody is going to talk to them. I myself, in the first year of my program, published a number of stories that relied on sources that risked their careers, their positions, and their reputation by talking to me. And if I was not able to guarantee that they would remain anonymous, they weren't going to talk to me. And in those cases, a lot of information would not have been made public. And so I have a real problem with the section on defamation. I think that if there's a loophole, any loophole whatsoever, where somebody can go after a journalist and demand their sources, I think that infringes on the free press. And so with those two objections, first of all, that we have to include independent journalists, and second, that we strike the language referring to defamation, I think that this would actually be a good bill. And I'd be happy to entertain any questions you might have.
Any questions for Mr. Iverson? Representative Heiner, I saw you first, so.
Thank you, Mr. Chairman. Mr. Iverson, thank you for your comments. Do you have some specific language you would propose for amendments to improve this bill as you discussed?
Mr. Iverson?
Mr. Chairman, Representative Heiner, I think that if we could just include "or independent journalist" in the first section that talks about what is news. I mean, I think that that would cover it, and certainly that is broad. But I think that we're dealing with a topic that is broad by its very nature. But I think if, as was brought up by Representative Zwanitzer, that if you have to show that, yes, I am a journalist, then I think that meets any standard.
Other questions? Representative Western, did you have a question?
Mr. Chairman, Mr. Iverson, you said obviously with the internet age, we've seen the landscape shift a little bit, and talking about your website. In reference to your specifically, I mean, what kind of reach are you getting right now? I mean, I know those metrics are pretty easy to identify through your website vendors. If you could maybe talk a little bit about that.
Mr. Chairman,
Mr. Iverson.
Representative Western, yes and no. The metrics are easy to find out. The reach of the program is pretty much statewide. There's 130,000 downloads, thereabouts, this morning. On any given week, I reach several thousand people.
Representative Heiner?
Thank you, Mr. Chairman. Mr. Iverson, did you mention that you would recommend striking the whole defamation clause, paragraph, which is subparagraph II on page 6?
Mr. Iverson?
Mr. Chairman, Representative Heiner, yes, it is my opinion that we should strike the entire defamation section.
Representative Lawley?
Thank you, Mr. Chairman. Mr. Iverson, could you read that quote again from the Wyoming Constitution on Free Press?
Sure. It's Article
Mr.
1,
Iverson,
Section...
please.
Excuse me, Mr. Chairman, Representative Lawley. It's Article 1, Section 20. It says, "Every person may speak freely, write, and publish on all subjects, being responsible for the abuse of that right."
And can I follow up?
Follow up.
Could you kind of help me understand how the latter part of that, being responsible for the abuse of that right, kind of interacts with the defamation part of the statute?
Mr. Iverson? Sorry, Mr. Iverson?
Mr. Chairman, Representative Lawley. Well, we have laws concerning libel and slander. Okay, so we can't, anybody can't print something that's not true. And certainly no self-respecting journalist would do that either. So it's my interpretation, being responsible for the abuse of that right relates specifically to libel and slander. That's how I would read it.
Follow up, one more.
Go ahead, proceed.
Why would it not also extend to defamation?
Mr. Iverson?
My objection, Mr. Chairman, Representative Lawley, my objection to the defamation part is that you can file a defamation lawsuit for just about any reason. Now, I'm not saying that they will go forward, but it's very easy to file a defamation lawsuit and then request sources from a journalist through it. And I just think that it's a loophole, and then I think it's one that we need to get rid of because, quite frankly, I think that it could be abused.
One more follow-up.
Follow up,
I'm not
Representative
sure I
Lawley.
understand the distinction between defamation, slander, and libel in this regard to the fact that anyone can bring it and request your sources. I'm kind of clear on how you're seeing it.
Mr. Iverson?
Mr. Chairman, Representative Lawley, as I mentioned, if you're responsible for the abuse of that right, it means that you're not going to print things, or you can't print things that are untrue, libel or slandered. And as I said, a defamation lawsuit doesn't necessarily have to relate to both of those. I mean, you could, as I said, you could file a defamation lawsuit for any number of reasons, and then it could be requested that you reveal your sources.
Okay. Any other questions for Mr. Iverson? Mr. Iverson, thank you.
Thank you, Mr. Chairman.
Any other public testimony? One last time. Okay, I'm closing public testimony. Committee?
Move the bill.
Moved by Conrad, seconded by Banks. Okay, committee, we'll just go through this. If there are no comments to start with, page 1. Page 2. Representative Heiner.
Mr. Chairman, I propose an amendment on page 2, line 17.
Okay,
I would propose after current to add a comma, strike or, and then after former, insert or independent. So the line would read a current, comma, former, comma, or independent journalist shall have a privilege.
okay. Seconded by Conrad. Mark, are you clear on the amendment?
Yes.
Okay, all right. Discussion? Okay, all in favor, say aye.
Aye.
Opposed, no. Okay, that amendment is adopted. Anything else on page 2? Page 3? Page 4? Page 5? Page 6? And page 7? Okay. Any other amendments or discussion? Committee? Question being called. We're voting on House Bill 91, News Source Shield Law. Mark, would you please call the roll?
Representative Banks,
Aye.
Representative Conrad,
Aye.
Representative Heiner,
Aye.
Representative Knapp,
Aye.
Representative Larson,
Aye.
Representative Lawley,
Aye.
Representative Tarver.
Aye.
Representative Western.
No.
Once again, I'm sorry.
No.
No. Chairman Burkhart.
Aye.
Ayes are 8, noes are 1. This is a do pass with amendment.
Okay. House Bill 191, News Source Shield Law with amendments has passed the Minerals Committee. So the next bill up for, thank you, Chairman. And you'll carry your bill on the floor, correct? I will. Okay. Next bill up is House Bill 190. And after sitting here for quite some time, oh, he is back. Chairman Harshman, please come on up. And Chairman, thank you very much for your patience with this. We had some confusion this morning. Chairman Zwanitzer managed to make profuse use of a shovel and a tow truck.
Sound like it. Mr. Chairman, I have just an amendment on staffing. You want me to distribute that now?
You can, and I'll announce to the committee. Mark, have you distributed that one?
Yes, everybody has the one that's inserted.
Okay, so committee, there was a mistake in printing, and you have page 16 as a separate page. Okay, you have page 16 as a separate page, and the reason is the way it printed 15 and 16 or 15 and 17 are back to back. So as you get to page 15, go to the last page in your packet, that's 16, and then come back to 17. I hope that's very confusing to everyone. Is it? Everybody has it?
I have it.
Okay, all right. I'm just reading the note I was given to by staff. So with that, Chairman, thank you for your patience this morning, and please proceed.
Morning, Chairman and members of the committee. Thank you, Mr. Chairman, for hearing this bill, and appreciate it. No, I'm glad to be here at any time. So working at your pleasure, committee. So appreciate you hearing the bill. Mr. Chairman, you'll recall when we both were on appropriations back in the good old days. We ran this same concept in a budget amendment, and it was 2014 and similar concept. And what we accomplished, and then of course, the next year coal collapse, and we went on about a 7-year slide where we've finally kind of come out of it financially a little bit.
Chairman Harshman, if I might ask, if you would give the committee, we have quite a few new members, a little bit of history behind the reason it came up in a budget amendment before, and that to kind of preface this a little bit, if you would.
Sure. Well, Mr. Chairman, we used to have a little bigger budget bill, and we would put some more policy in budgets. I think we still can. We're in this kind of, it's always that rub between the executive and the legislative branch. But in this case, we ran this as an important idea to get in front of the body. And we accomplished two things out of that. The Integrated Test Center in Campbell County was a result of that. And then, of course, the core sample, which has been a big benefit to our energy industry, was established at the University of Wyoming. There were other initiatives, but and we have a lot of big ideas, right? But then the bottom fell out, and we've been in a financial crunch for the last 6-7 years. There's no doubt about it. And so now we've got some of this one-time money. Went from COVID with negative oil, Saudi-Russian price war, drove it down first before COVID. And then all of a sudden we come out of COVID where, the asset was a liability, minus 30 oil. And now this Russian-Ukraine war and then anyway, an amazing turnaround in some of that, and then infusion of federal dollars as well. So here we are today, we've got some one-time money. And the Appropriations Committee is I think in their current budget added over 160 plus million or more. So there's well over 300 million for the executive branch to use on these initiatives. So, Mr. Chairman, really, and when we talked about this bill, just really kind of bringing back some of these concepts to get our branch of government to partner, to provide some more ideas, to champion and to cheerlead, and to kind of go arm in arm with with all branches of government to really work on some of these ideas, because we've got really an incredible opportunity right now. So, Mr. Chairman and members, if you want me to go through the
Please
bill,
go-
I'll
go
go
through the
through
bill,
it rather
yes.
quickly, just because but members, if you flip over to page 2, we generally don't put findings in bills, but this has 3 short findings all on one page. And I think line 4, we're presented with multiple projects, no doubt about it. And to encourage our expansion and diversification, you go to Romanet 2, these have substantial potential. And number 3, Romanet 3, line 14, really a coordinated approach. And so, Mr. Chairman, then it goes over to page 3. There's created a select committee. And really, you can see the makeup. It's the value-added energy, economic development, industrial plan. And Mr. Chairman, you can see on line 8 on page 3, it's 3 members of the Senate. And it's spelled out that a member of Minerals, Appropriations, and 1 other appointed by the President. Flipping over to page 4, Mr. Chairman, same thing for the House of Representatives. The Speaker will appoint a member of this committee and 1 Appropriations, and then another member from the House. And line 19, page 4, Select Committee shall. Right? They'll pick a co-chairman, and then on page 5, it talks about some of the things meet as necessary. And it talks at the bottom of page 5, line 21, the governor may. We don't tell the governor what to do, right? Very often it says may, because most of those times when we push shall, it gets vetoed. But so very respectably, he may, and he already has in many cases, right? And he may appoint another legislator to sit on there too, and could be a member of this value-added committee, or could be another legislator. And you can read some of these ideas and initiatives. These are not new to Wyoming, but some of them are kind of expanded, but we've got some incredible opportunities. So with paragraph A on line 14, page 6, right? And then I don't want to read this whole bill to you, Mr. Chairman, so you can skim through that. A, B, C, all these things are really important. E on page 7, line 13, and I included in there nuclear energy and hydrogen. The Nuclear Energy Task Force way back, it's been 12 years ago, where we cleaned up all of our laws, allowed us to be an agreement state. A lot of these things that you'll do will take a decade to show the fruits of your labor. And so I encourage you to just keep working on it. These are not quick turnarounds. And so that's that part. Okay, and then, Mr. Chairman, the deep water ports, you and I have worked tirelessly on that. We first brought in appropriations, the Coal Port Litigation Fund, I don't know, 2013 or 14, somewhere in there. And we've worked that. We've worked with Native American tribes. We worked with everybody along the coast to try. And there's some movement on soda ash on the West Coast. There's some other movement as well going on. And so it's exciting as well. Mr. Chairman, I won't read all that on page 8. Did add on page 9 some of this economic development. I think there's opportunities all across our I-80. And maybe there's land purchases we got to explore, trades, those kind of things. There's some, great opportunities for just economic development, tourist development. Okay, so Romanet 2 on page 9, starting on line 15, basically working together. That's talking about the legislative and executive branch working together. And again, on page 10, talks about more legislators can be appointed. The governor sees fit. And some of the groups we can cooperate with, Mr. Chairman, we've worked with Idaho National Lab, others. We've on top of page 11, so that's spelled out in there. Talks about reporting times on page 11. Mr. Chairman, I'm flipping over page 12 and page 13. It's got some dates and then where the amendment would come in about staffing, and that's what the amendment is about, Mr. Chairman. If you look at your amendment, it adds a new H on line 3 of the amendment. And basically, the select committee staffed by the Legislative Service Office. Any task force created by the governor is staffed by the governor's office. And then it renumbers the current H and J into a J and K there. And finally, Mr. Chairman, the dollar amounts are listed out for kind of each of these areas, but it's pretty flexible, really. And then the total fiscal note, if you flip over, you got the fiscal note of the bill. This bill only asks for an appropriation from the general fund of $100,000. And then the rest of that money, if it's expended, you can see in paragraph 2 of that budget bill, is from this 300+ million that appropriations committee is that we've already appropriated to the executive branch. So really no new money, just less than 1% potentially, even if we spent all that, which probably wouldn't happen. So, Mr. Chairman, I'd just kind of quit talking, and if we want to visit some more and answer any questions, and about this issue more, more than anybody, so appreciate conversation. Thank you.
Committee, questions for the chairman? Representative Conrad.
Mr. Chairman, thank you. Representative Harshman, thank you also. Just a quick question on page 11, beginning with line 13 and also line 18. Are the deliverables there, May 15th and August 31st, are those aggressive, or do you think you can meet those, or this bill can execute?
Chairman?
These dates too, obviously these are aggressive. These would be broad kind of outlines, broad kind of directions. And and then it would become more specific as time goes on. But yeah, that's pretty aggressive for anything real specific.
Committee, other questions? No? Chairman, I do have one on page 5, the top of the page, for the select committee to meet as necessary. Normally, we generally schedule our committee meetings for the interim and that. And I guess what I'm getting at here is I don't think we want the committee to be meeting continually. That could happen. There are a number of programs out there, projects that are ongoing. Could you talk a little bit about the meet as necessary?
Mr. Chairman, I think the idea is really, and particularly in the Zoom world we're all in now, and I think you legislators know, and the chairman appoints little task force out of your committee to work. Most of that meeting is done over Zoom. And that's the way maybe some of this would work as well, I think. But being able to respond if the governor's office says, hey, we've got to do this or this, and hey, we got to meet and get this going. So I wanted to, again, leave with some flexibility in that. Thank you, Mr. Chairman.
Other questions? Representative Heiner.
Thank you, Mr. Chairman. Chairman Harshman, in this proposed bill, it gives the governor permission that he can appoint one or more task forces for various things on page 6 on line 4. I've seen the governor appoint task forces without legislative directives. So do we really need to have that in statute, whereas he can already do that?
Chairman?
Mr. Chairman, Mr. Chairman, absolutely, he's duly elected, he can do that. But I think it just spells out kind of a cooperation that we're trying to propose with the legislative and executive branch. So certainly the word may is really key there. So thank you, Mr. Chairman.
Other questions for Chairman Harshman? Other questions? Representative Larson.
Thank you, Mr. Chairman. So in your bill, I just wanted to know if you see where there's efforts to make sure we're getting input from across the state. If you could maybe point that out.
Chairman Harshman.
Mr. Chairman, I think fair question. I didn't put in this bill, hold meetings around the state kind of thing, but I think, we're all so accessible. All our cell phones are on the internet, and I think back in 14, in fact, I heard a lot from Sweetwater County, obviously is prime position, and resources and location, but, so I didn't put that in there. I think we're, as a citizen legislature, really open to the people. And I do get an occasional email that says, I want to hear back from you, not somebody on your staff. And then I always have to reply, it's me, my wife refuses to help me. So, but our citizen legislature is really open. So yeah, I didn't do that just to keep the flexibility, but good question on that. Thank you, Mr. Chairman.
Other questions? So, okay, committee. So Chairman Harshman, I have one because people have obviously seen the bill and we already have a number of organizations handling similar issues. I think I know what you're getting at with the bill. But if you would please address the issue of, we have the Energy Authority, we have the Business Council, the Governor's Office, who are all doing something with economic development. I guess I'm asking you if you could tie that all together for me.
Thank you, Mr. Chairman. And really, that's, I think, the key point of this bill and where I tried to write it with flexibility. We want to really be in the supportive role as the appropriations branch of government. It's going to cost money. And I think the more of you that are involved and know the backstory, and you don't hear the backstory in January when you come here, I think is really helpful to our state. And then I think the other thing is, I believe in group genius. I think that's our process. I think that's how you get ideas, and having some more folks involved who have other circles of influence and have other life experiences around our state. And so, boy, totally as a supportive and cooperative and partnership is the spirit in which I'm bringing this, and really to keep all of us up to speed, because I don't think any of us know exactly all the work that's going on. It's incredible what the executive branch is doing right now, and we want to be there to support and appropriate in the right way.
Okay, so Chairman Harshman, I've heard some things on the bill, and one question that has come up is that this select committee would have approval authority over some of these projects, maybe some of the ones that are already going on or new ones. How do you address that?
Mr. Chairman, I'd say absolutely not. And I think it's not the point. It's more about the education ideas and help push the cart down the road. That's what we're trying to do with it, and all working together. Thank you.
All right. So committee, I'm gonna take a brief historical privilege here. You've seen mentioned in here the Heartland Complex in Alberta, Canada. Back in, I believe it was 2014, a group of legislators and others went up there to look at that facility. I didn't go, which in the end was good because I understand it was 34 below when they got off the airplane. But the concept was, could we do something like that in Wyoming? We talked about it, then the economy kind of tanked, some other things, and it kind of fell by the wayside, but it was a good idea that we never fully developed and that. So Chairman Harshman, is that also the concept with this bill, is to maybe back up a little bit and work on those thoughts that were had by the legislature 8 years ago?
Mr. Chairman, I think precisely, and I think there are some places in this state that are uniquely positioned to do that. And then the other part of this bill, the task force ends when Governor Gordon's term ends. So it gives us kind of 4 years to start laying some of this groundwork, which will, as I said in my opening comments, will probably be a decade. You know, it takes time to start planting these seeds. So, but back to your original question, I think you know this better than anybody, but Campbell, Carbon, Sweetwater County, incredibly positioned for ideas like that.
So, and so thank you, Chairman, for the committee. When that concept was kind of first floated in the legislature, those were the 3 counties that were being looked at. And Sweetwater was probably kind of out ahead of most of them, just due to the fact that they already have somewhat of an infrastructure for that, and probably demonstrated the biggest interest in proceeding with a similar program. So, okay, any other questions? Representative Heiner.
Thank you, Mr. Chairman. Chairman Harshman, maybe you could provide some clarification for me here. As we go through some of these task items that you're proposing in this bill, it seems to me like a lot of these fall within the purview of this committee and the Joint Minerals Committee with Minerals Economic Development. So it seems like we're already tasked with this kind of responsibilities to oversee this development within the state. Is it possible for this committee to create a subcommittee under this committee to pursue any of these items that we feel may be important?
Chairman Harshman?
Mr. Chairman, to answer the question, I think absolutely for the chairman's prerogative. Chairman appoint those all the time, and absolutely.
Other questions? Okay, thank you, Chairman. Hang with us.
Okay.
So I'll open it for public comment. Any other legislators in the room? Come on up.
Mr. Chairman, good morning,
Representative.
committee. I spent 4 years, served 4 years with,
Representative, just for the record, identify yourself.
will do, Representative Bill Henderson.
Thank you.
I served 4 years on this committee, Mr. Chairman, and I learned a lot. And I want to share with you that one of the things I learned from the leadership of the committee, both here in the House, as you were talking about and referring to in the Senate, is not overlook the opportunity to have a conversation about these important topics for the benefit of the local communities. These opportunities that are provided, I think this will help generate, will have their own lakes, if you will. And I think we should do everything we can to support that. And I strongly support this bill.
Okay. All right.
Any questions, I'd be glad to
for
try to ask them.
questions for Representative Henderson? Okay, thank you, Representative.
Thank you.
Anyone? No, I see no other legislators. So anyone from the governor's office? So For the audience, the attendees, there is kind of a pecking order here, as you figured out.
Good morning,
Proceed.
Good morning, Mr. Chairman, members of the committee. My name is Randall Luthi. I'm the Chief Energy Advisor for Governor Gordon. And first of all, I bring you greetings from Governor Gordon. Greatly appreciates all of your work, greatly appreciates the legislature as a whole, as we all work together to make Wyoming better. I wanted to start my comments off with actually recognizing what Speaker Harshman alluded to. And as we have often said, you know, everything that needs to be said has been said, but not by everyone. So this gives me an opportunity to do that. You know, I think we should take a minute and recognize how momentous it is that we're having this discussion about this bill. Just go back a couple of years ago. No drilling rigs in Wyoming were operating. Coal had gone down to one of its lowest points. Very little business activity. And now we're talking about the great opportunities that Wyoming Energy, Wyoming Industries can have. I think that's important. That's a great change. Governor Gordon supports that change. We all think it's a great idea. Governor Gordon supports this bill, but he does have just maybe a couple of observations about it as you go through the process. As you look at the list of projects, there isn't a one on there that we don't wholly support. There are also many other projects may actually become available as we move forward. And I think we should be open to those and be ready to move on those. We are working actively every day to bring more businesses to Wyoming. We are working every day to see that Wyoming's economy continues to improve and that we continue to be the largest net exporter of energy in the nation. We've mentioned the governor's office and what we're doing. We have been able to staff up. I've been around for a while, but we were able to add a major projects manager. We have the Wyoming Business Council. We have the Wyoming Energy Authority, all of which work hand in hand and in coordination and attempt to do the very things that this bill wants us to do. Now, I'm not saying we can't do more because we can. And I'm not saying we don't need the help because we can always use the help and we appreciate it. The only observations the governor would have is this piece of legislation creates quite a few new task forces, or a minimum number, depending on how you look at it. We have a select committee, we have task forces, and then we have the governor has the ability to appoint more task forces. All great, but we're starting to talk about a lot of people, a lot of bureaucracy. And as you move forward through this process, the governor's office stands ready to work with the sponsors of the bill to make sure that what we do actually results in bringing more businesses to Wyoming, and that we're not just meeting with ourselves, but we're actually going to bring together the forces that we need to bring this forward. So with that, I wish you well as you work the bill. These are great concepts. And we do stand ready to help it in any way we can.
Questions for Mr. Luthi? Any questions? You're going to let him off that easy? Okay, Representative Heiner.
Oh, well, I thought I might. Thank you.
Oh, Mr. Chairman, I enjoy the grimace on Mr. Luthi's face. This is going to be a softball. How is the governor doing after being diagnosed with COVID?
Thank
Mr.
you.
Luthi.
Mr. Chairman, Representative Heiner, it is a softball. The governor had probably what I would describe as a runny nose. He never quit working, as my phone will attest to you during the time he was home. He's back and at it and going full strength.
All right. Okay, thank you, Mr. Luthi.
Thank you and members of the
Did
committee.
you bring anyone else with you from the governor's office?
I did not.
Okay.
They thought maybe I could handle this one. All right.
Okay. And
Thank you
did
all.
well with it. Thank you. Okay, agencies. Come on up. Proceed.
Mr. Chairman, my name is Josh Terrell. I'm the CEO of the Wyoming Business Council. Mr. Chairman, members of the committee, thank you. And And Representative Harshman, thank you for bringing this forward. I do think a lot of things have been said that needed to be said by both the folks testifying as well as by your committee. I think the excitement around economic development and the opportunities in Wyoming it's not just palpable, it's pretty impressive and exciting. And all of us in the agency world who are kind of on the ground doing that work, we can feel it. We can feel it in the communities. We can feel it from the legislature, and the cooperation that we have been receiving. It's a stark difference in the 3 years that I've been in this role. And I think it's really impressive, and I think it's exciting about that. And I might just put a little bit finer point, because I think Representative Heiner mentioned something that is important, that the cooperation between our agencies and this committee is a really key component. And a lot of that work can be done, whether that be through a subcommittee or be through the interim or be with these committees directly. I guess I'll come at it from this metaphor. So maybe many of you have seen rowing, where there are many people in a really kind of an interesting hull boat, and it's cruising down the river or in the ocean somewhere, and they've got one person in the front sort of yelling out in front or back. I live in Wyoming, so I don't see a lot of water, but they've got somebody yelling out the commands to stroke, and then they have a number of rowers they're rowing, and I think everybody can agree, if you want to make that boat go faster, I don't think you add more coxswains, you add more rowers. And so I think in this case, where the gist of this is right on the money, and that is in the appropriation, that is in the focus, that is in the cooperation, I think we need to make sure we add more rowers, not necessarily more coxswains. And so I think that would be, my suggestion is that in spirit, this is right on. In spirit, we're doing a lot of these activities already. And not just in spirit, but in action, we're doing the activities. And in spirit, we have the cooperation. I think this shows it, right? And I think that this committee has a really big opportunity to create the policy and funding mechanisms in order for us to do our job. And so what I would say is that this is, again, in spirit, great. And I think we're doing this. And I think the key is we want this to move faster. We want it to move better. And we want to do it in the structures that we have. And I think the key is, again, from the agency, you mentioned a pecking order, Chairman. And as the low man on the totem pole in that pecking order, I can tell you on the ground, we definitely need the folks to be out there in the state doing this work and looking at all these opportunities. And I think that would be a great place to appropriate. And again, the cooperation's there. I think the excitement is there. And I think the cooperation is there. So again, I'll stand for any questions, but I want to thank the representative for bringing this forward and for those who co-signed.
Okay. Any questions for the director? Any questions? Director, thank you. And you aren't low on the totem pole, as the saying goes. Probably not a good analogy, but you spoke up first. So any other agencies?
Thank you, sir.
Okay, none? Mr. Krieger, do you want to testify for the governor's office? Okay, I just thought okay. Anyone else here wish to speak on this bill? Any members of the public, please come up. And identify yourself for the record, please.
Hello, Mr. Chairman and members of the committee. My name is Sean Murphy. And hello, Mr. Chairman Harshman. It's good to be here to share some public comments about this. I'm really here representing a local company called Bison Blockchain. We are a data and Bitcoin mining company, and I can share more about that, but I really want to speak to the bill, and that is that I'm just very in support of this bill. This is at the right time for the right reasons, and like we've heard, there's a lot of momentum and people that can be involved that can move this forward. And to give this some context, I wanted to just call to mind the Great Seal of the state of Wyoming. I don't know if the members of the committee can think of everything that's on that, but there's 4 words: livestock, grain, oil and gas, and then mines. And it's very interesting because I never thought of myself as a miner until we began this business where we're mining Bitcoin. So in ways, we're like a data center where we're processing data, but we're also miners. And it's funny because there's a picture in the Wyoming State Museum of a modern miner that looks nothing like us. We're data technicians, we're mining Bitcoin. And just for some context of scale, Microsoft is probably using around 200 megawatts of power for all of their data mines. They're the largest consumer of energy. Industrially speaking, the site that we're building in the business park near Cheyenne is 30 megawatts. And then down from there, the other data centers are around 4, 3 and under. So we're very large, 30 megawatts. And I think why this is so important right now is, and we have the blockchain select committee, I get that, but the real issue is energy. In our world as data miners, modern miners of Bitcoin, it's energy consumption. And there were challenges last year in this committee on the Senate side with deregulated power zones and these issues to help get everyone in the same boat, like we heard about in terms of energy consumption, are very important and needs very focused expertise. And one example of that is really an idea with this, and using the Alberta model. We actually have team members on the site from Canada that are helping us develop these mines. And they shared that the model in Alberta is a royalty-based model, and many of you are familiar with that their resources, their state resources, there's a royalty. And the idea that I want to share with everyone here today is to think of Bitcoin as a resource. It is a resource and it is going to appreciate. It's been down in the news, it's going up, but if we're looking at a 10 or 20-year plan, that is a resource I think the state of Wyoming should be interested in either having a royalty of or creating a treasury to hold Bitcoin. This is going to be a very valuable resource, in my opinion, and analysis. So anything we can do to reflect that Alberta model of resource management, I think is very smart. I think it would be a royalty on the Bitcoin that is mined in the state. But to do that and encourage more mining and data processing, it's an energy issue. It's not a select committee on blockchain issue. It's looking at the power utility companies and understanding their incentives and how to do that in a way that we're driving more energy consumption in the state for these large companies like data processing, like your data centers, like Microsoft, like Bitcoin miners and other mining operations. So it's going to take a concerted effort and expertise. And I'm going to keep going back to this. It's an energy issue. We're using 30 megawatts at one site, and we've leased state land on the east side of Cheyenne to set up more mines. And that would be another 30 megawatt facility. So we're immediately almost using as much energy as Microsoft on a couple of their substations. So again, these are big projects. This bill looks very supportive of that, and we're just excited to see that and the support, and that this idea of this 10-year, 20-year plan is reflected throughout all those. Thank you very much for letting me share these comments.
Questions for Mr. Murphy? Any questions? Mr. Murphy, thank you.
Yes,
I
thank you.
appreciate the different point of view for the committee. Thank you very much. So, anyone else wish to speak on this bill? Last chance. Okay, with that, I'll close public testimony. Committee?
Move bill.
Moved by Conrad, seconded by Lawley. Okay, we'll just go through the bill. Page 1, page 2, page 3, page 4, 5, 6, 7, 8, 9. Okay, 10, 11. 12, 13. Yes, Representative Larson.
I'd like to move the proposed amendment that was passed out to us.
Okay, where are you at?
Page 13. Just make insert and renumber as necessary. Insert the select committee created under this section shall be staffed by the legislature or legislative service office. Any task force created under this section shall be staffed by the office of the governor.
Okay.
Second.
Okay, seconded by Conrad. Any discussion on the amendment? Okay, Mark, do you have a copy of the written copy of the amendment? Okay, so the amendment is, the proposal is to adopt the suggested amendment by the good chairman. Any discussion? Question being called. All in favor, say aye. Aye. All opposed, no. Okay, the amendment, the proposed amendment, 3701 is adopted. We're back to the bill. Anything on page 14 or 15? Page 16 or 17? Okay. All right. Representative Heiner.
Thank you, Mr. Chairman. Mr. Chairman, I appreciate this bill. It's at the right time with the right information on it. There's a lot of excitement within our state right now about what's coming on the horizon. And whereas I have a lot of voids in my head with nothing in it, the good chairman has got so many ideas in his head, and I certainly appreciate that. But I believe that this committee that we're on, we have a great opportunity to lead forth and coordinate some of these efforts. I would like this committee to stay as the central focus of the minerals and economic development. And I believe that we ought to take many of these topics as interim topics, and maybe the good chairman could assign some subcommittees within our joint committee of minerals to address some of these topics. I think they're great ideas. I just think they're fantastic ideas that we need to focus on. But rather than develop a separate task force, I would like to keep it within our joint minerals committee to steward and go forward with this, and maybe ask for additional appropriation for the interim such that we can have some additional meetings. I'm here to work, and I want to be involved with the economic and minerals and natural resource development of Wyoming. And I think this is a great opportunity and a perfect time to address some of these situations. Thank you, Mr. Chairman.
Representative Lawley.
Thank you, Mr. Chairman. I just want to say, as a new legislator, I love this idea. I think it's a kind of strategic cooperation that I see actually needed in a number of areas that we face as legislators, but in particular, I think it will allow us some legislative agility and effectiveness through this process that this bill creates. So again, just speaking as a new legislator, I really like this approach.
Sorry, Representative Banks.
Thank you, Mr. Chairman. I was raising my hand, but the good representative here to my left beat me to it. I share the similar concern. I read through the bill and it's minerals, business, and economic development, and I just think that's what this committee is tasked to do. And so when I see $3.2 million to task somebody else with something that we're tasked to do, I have some questions about that. So I would agree with the good vice chairman that we should be the ones leading the charge on this, not passing the ball off. So I would like that we be included in this, and maybe instead of creating a whole new section, have members of this body. I'm here to work too, and going forward, I think that we can do that without spending and creating new.
Okay. Representative Larson.
Thank you, Mr. Chairman. The way I looked at the bill is $200,000 would be expended for administrative purposes. The rest would be going towards looking into these projects and developing these projects. So I think the 3 million is going to be a good investment across the state. So thank you.
Comment? Other comments?
Question.
No, well, I might have a comment.
Sorry. I hope you do.
So for the committee, you'll get plenty of opportunity for subcommittees and assignments and that sort of thing. But I'll be blunt about this. Frankly, with everything that's going on in the state, there is not enough time for this committee to get together on all of these. We will divide and conquer with subcommittees and that. You know, I know of a number of projects and I have non-disclosure agreements on them. If they all come to fruition, it's a $12 billion investment in the state of Wyoming. One project alone will be the biggest industrial project the state has ever seen. And we need to be able to act very efficiently, very quickly, adjust to the situations. Representative Heiner, I've included him in some of those conversations of some of the things we're doing. And we just need to be very, very nimble. One of my comments initially looking at what the good chairman had proposed was the dates. Very aggressive. But if we say, well, we'll study it, we'll take a look at it, and we'll come back in a year, I can tell you things will be different in a year. We need to start moving on some of these very quickly and very nimbly. And I think that's what this bill does, is lets us provide an input through this committee, through subcommittees, through the select committee, to the governor's office. We as legislators can't do any of this development. That's just not our job. That's not what we do. We sure can set a framework to help companies succeed and to help the executive branch move forward quickly. The good chairman mentioned the amount of money appropriated to the governor for these things. The reason for that historically was the governor needs to be able to act quickly without coming back to the legislature, waiting a year. We only meet once a year. Even if we have a committee, we can't pass any legislation until the next session that we're back. So I just ask you to give that some thought. We need to really move forward with some of these. And we've already started discussions with some companies that are in progress. And put it this way, if half of these come out and work through, we're in for a tremendous economic future. So, Representative Tarver.
Mr. Chairman, thank you. So I just have a question on the bill. This is a cheerleading bill, and maybe Chairman Harshman can help me with this. Does it provide an attack dog approach on any of this stuff? Will it help? Does this give us any teeth to fight back from, let's say, federal overreach or any other agencies that are entangling our energy companies? Will this provide any attack dog mechanisms, or is it strictly just holding hands and hugging?
Chairman Harshman, I'll let you address that one.
Sure.
Because I personally don't like holding hands and hugging, so.
Yeah, Mr. Chairman, and Mr. Chairman, there is a section in here about litigation to support that. We were, the House of Representatives in particular, years ago were the first.
Chairman, could you get just a little closer
Were
to
the-
that mic?
yeah,
In this
thank
room,
you.
they tend to be, I
Sorry.
don't know, they're a little less sensitive.
And, yeah, Mr. Chairman, and so really, and it was the House of Representatives in particular, maybe a decade ago, that started the Coalport Litigation Fund and was really proactive on that. And this is contained in this bill. But I think the idea is, and I think you heard the executive branch, is to really be proactive and get our branch really proactive on that. And it's, it's an interesting balance, and that's the balance I'm trying to achieve. Both branches of government have their lanes, and but I think part of that thing is too, it's the education piece of all of us. There's a lot we don't know, and the more members we can kind of get into those conversations, I think is really good. It's good for our body. It's good for the state. I mean, there's a reason that, the nuclear plant is coming to Kimmerer. And I'm not going to say it in public, but there's a reason why it's going to Kimmerer and not Glenrock. And so I think this branch is very important to be involved in all these conversations. And again, I don't want this, it's not a thing. Governor's office is doing great. Governor Gordon, former Speaker Luthie, who served in the House of Representatives, was Speaker of the House my second term. Director Durrell, everybody. I mean, it's not about any of that. It's about really full-on cooperation. And it's going to take all of us. Much like when Governor Hathaway really brought the coal industry after the Clean Air Act shut down Appalachian coal. Why Wyoming and not Montana? Well, there's a reason for that too. And there were key legislators involved with the governor back in those days, why this coal industry is not set in Montana where there is less overburden, where it's easier to mine. And so by us being really proactive and going to work, and I'll tell you about work on this stuff, yeah, so it's going to be really important to add our voices to that. So thank you, Mr. Chairman.
Thank you. Representative Lawley. We're kind of out of public testimony and questioning, but go ahead if you have a
Well,
statement.
I just about the comments about, I don't see it as either or, this bill or this committee seeks to take on, it's both and to me. And I see, again, the wisdom of the nimbleness that this approach can provide that the subcommittee alone can't, particularly with the appropriations committee being involved, someone from appropriations as well as the governor's office. So I don't see it as an either or. So. Thank you.
Okay. Committee? Question being called. Mark, please call the roll. We are voting on House Bill 190, Wyoming Value Added Energy and Industrial Plans as amended.
Representative Banks,
No.
Representative Conrad,
Aye.
Representative Heiner,
No.
Representative Knapp,
No.
Representative Larson,
Aye.
Representative Lawley,
Aye.
Representative Tarver,
No.
Representative Western, Chairman Burkhart.
Aye.
Ayes are 5, noes are 4. So do pass with amendments.
Okay, House Bill 190, Wyoming Value Added Energy Industrial Plans as amended, has passed the Minerals Committee. Thank you, committee. Thank you, Mr. Chairman, and that. And I see no other business before us. You have about 15 minutes of free time before we have to be on the floor. Thank you. We are adjourned.